Number 86, U.S. Bank National Association versus Nelson. Let's wait a moment and give these gentlemen an opportunity to leave the room.
See you, Your Honor.
One moment. Let's wait for Mr. Hertzberg.
I'm sorry. Thank you, Your Honor.
You're welcome, sir. Counsel?
May it please the Court, my name is Jared Foley from Gall, Dreyer & Berkey, and I represent the appellants Kenyatta Nelson and Sophia Nelson. May I reserve 3 minutes for rebuttal, please?
Of course, sir, you may.
Your Honor,
So let me ask you a question. Did you have an opportunity to make any arguments about standing in opposition to the summary judgment motion?
in opposition to the summary judgment, we did not make we did not challenge standing
Since
there.
you
However,
didn't, how are those arguments preserved in your view?
well, in several ways. As an initial matter, the issue of whether or not it's been waived is largely moot as a result of Real Property Law 1302A, which was enacted this time about December of last year. 1302A provides that an issue of standing in a foreclosure action can be raised at any time prior to a foreclosure sale, which hasn't happened here yet.
Well, but there's an issue as to whether it applies to this case, because arguably it would undo actions that were already taken in this case. I understand the two sides of this are there are actions that have been taken, such as summary judgment, and it's already water over the dam. And the other argument is, no, the mere fact that there has not been a judgment of foreclosure and sale makes the new law applicable to this case.
Well, I
But
think
I think that's, you know, that's the difficult question that we have to answer.
Understood. And I think that I would refer to this court's decisions in Henry Gleason and in the matter of Honore Bank. In those cases involved remedial statutes, just like the remedial statute here, where the case looked at several factors to determine whether or not it's a statute that would apply retroactively to pending litigation. They looked at the legislative history to determine whether or not it was a clarifying statute.
Let me just stop you for a second, because I don't think the question is whether it's, well, maybe it is, depending upon how you define retroactive.
Right.
So are you saying, I guess my question, if I actually asked one, is more to, what does that mean, retroactive? Assuming that it could apply to this case because it's still pending.
Right.
Have there been steps taken in the case that make that not applicable?
So I'll take a step back, and we look at the standards in Simonson, which it sounds like you're referring to, where that case involved a statute that was purely procedural. It did not address a remedial statute in the way that we're talking about here, a statute that was designed to correct imperfections in the law.
Well, can it be both? I mean, can it be procedural and remedial? How is this?
It can, but I would also, again, look at the way the analysis done by yourselves in Henry Gleason and on Bank. In those cases, when you looked at the statutory history to determine, one, whether or not it was a clarifying statute, to determine whether or not the intent was to address overreach by judges in other courts, and whether or not there is a sense of urgency. And all that is present here, in fact. So you have the legislative history, and I would refer you again to the sponsor's memo in support of Chapter 739. It specifically says that this is a statute that's meant to clarify. And if you look at the bill jacket, many of the letters in support also note that's a clarifying statute. Also, the legislature took specific aim at courts that found that standing could be waived if not raised as an affirmative defense, saying that ownership of a note is a, quote, clear requirement for foreclosure or cause of action. Clear requirement is the language that they
You
use.
mean as distinguished from being a holder of a note? Is that, are you saying that this statute changed that?
I don't think it actually changed anything. I
Okay.
think what it's saying is that to bring a foreclosure cause of action at bottom, you need to show that you have some legal or equitable interest. So if you're, say,
Okay, but that doesn't necessarily mean ownership, right? It could,
Well,
I mean, you could be the holder of a bearer note.
yes, you could in theory, I
Okay.
suppose. But, so this statute looked at, specified that it was a clarifying statute. It specified that it was meant to correct overreach by judges, that found that standing could be waived. And
If the statute didn't change anything, wouldn't the ordinary rules before the statute have been, if there's a summary judgment motion and you oppose it on one ground but not any other ground, here the only ground was that it was essentially moot, had already been decided.
Right.
And there's then a grant of summary judgment, that's the end of it.
Well, for
Did
the
it change
purposes,
that?
I think for the purposes of preservation, you need to look at the purpose of preservation. Preservation is meant to give the court and to give the opposing counsel an opportunity to, notice of a potential error and give them the opportunity to address that error. Given the unique procedure here in a foreclosure proceeding, this opportunity was had when we raised the issue in the cross motion to dismiss, in addition to raising it in our pro se answer, where we challenge ownership. Now,
Let me just ask you a question. Let's assume for a moment that you did fail to preserve it. The way I read the record, standing wasn't raised until the cross motion to dismiss after the referee's judgment. So it wasn't preserved before then. But the question is, and I don't know, I'm not sure I know the answer, but it seems the question is whether or not standing is an element of the cause of action. If it's not an element of the cause of action, if it's a just disability question, then your argument may have value. If it's an element of the cause of action, then you have a more difficult role to hold on the preservation issue. Would you agree with that?
well,
You understand what I'm saying? On one side, it seems to me you have a cause of action, and the question is whether or not standing is an element. And then on the other side, you have the question of just disability, which is really the limits of the legal issues that the court can consider. And if standing is an aspect of just disability, then that's a threshold issue that has to be considered at the outset of litigation, and it comes before the question of the elements or anything else. And that's whether or not the question is, can the court exercise jurisdiction? And it's not a question of preservation. It's a question of whether the court can take any action then.
Right.
See the difference?
I do.
So if it's a just disability question, then we get to your next argument, which is that it's retroactive.
Right.
If it's not, then you don't.
Well, I would say that this is a threshold issue. It goes to whether or not you actually have the ability, have any interest at all in this thing that you're trying to foreclose upon.
But then what about 3211E? And obviously, the new statute overrides that in
Right.
foreclosure actions, right? But certainly, standing can be brought as an affirmative defense, and in fact must be brought as an affirmative defense in lots of other kinds of actions. So how could that have to do with just disability if you can waive that defense in other actions, but not in this?
Well, I mean, I would actually, you talk about other kinds of actions, but I would actually refer to the example that was put forward by opposing counsel in trespass actions. In those kinds of cases, courts have found that possession, so in a trespass action, you need to, trespass action is brought when there's interference with a possessory interest in property. But several courts have found that possession is an essential element, right? You can't bring that trespass action unless you show some kind of interest in this first. I think that's the kind of thing that we're dealing with here as well.
You're saying that the plaintiff in a foreclosure action would need to say, I'm the holder of the note or the owner of the note or somebody with otherwise the legal ability to enforce the note, and that's an element of their claim.
Yes. And here's the thing, there's a clear gap in the chain of ownership here.
Before you get to the gap here, has any court ever held that it's an element of the claim?
Well, I would refer this court to Campaign versus Barba and Whittleson versus Jamaica Estates. In those cases, they made clear that ownership is part of the prima facie case for a foreclosure action.
And did you ever make that argument below?
We made the argument on our cross motion to dismiss.
You never, as far as I read the record, it wasn't because it was an element of the cause of action, though. I thought that you made that element argument for the first time in your re-argument motion at the appellate division.
Actually, I read it differently. I read it as making actually both arguments. That in sense, ownership is whether conceived of as an issue of standing or whether conceived of as an issue of, as an element. You have to prove that first before you move on.
At the trial level, you were making the argument as an element of standing, or I think capacity, but it was standing. It wasn't as an element of the cause of action. The first time I read the record as the element of a cause of action argument was made at the appellate division in a re-argument motion. And then you make it here, but I don't think that, I read the cites to the record, but those seem to me to go to standing as as an affirmative defense.
I understand, Your Honor. I read those as kind of intertwined
Well,
arguments.
how can an affirmative defense also be an element of the cause of action? One requires pleading by the plaintiff, and the other requires being raised by the defendant. How can it be both?
Well, I think our argument was that whether it's conceived of as an element or conceived of as an issue of standing, they haven't proven either,
Well,
given...
I thought I'm over here, sorry.
Yeah.
The masks, I know, make it difficult. I thought your argument was that they have to establish standing.
Yes.
And that's what you're arguing, that they didn't do that. So to that extent, it is an element of the claim. They cannot succeed unless they show that they are properly the ones to bring this action.
Well, let me deal...
And your argument was that, certainly what the dissent was arguing below is, if you find it anywhere in the pleading, that's good enough. It doesn't have to come under the title affirmative defense.
That's correct.
Let me just, before I forget, can I just clarify with you, do you agree that Rule 3211 requires the assertion of standing, wherever it may be, whatever you label it, right, as being lacking from the plaintiff's side, at a particular point during the litigation?
Well...
Do you think 3211 covers standing?
I believe 3211E does cover standing.
Where would I find it?
Or rather, standing isn't actually mentioned, but it's kind of like the catch-all at the end of 3211E. But my view on how it was raised is this, that standing, when the issue of standing is actually pled on the face of the complaint, there's no need to plead it separately.
I understand, but if it doesn't fit under 3211, you don't have a problem, right? Because you're arguing at some point you raised it.
That's
Maybe,
correct.
maybe not.
Right.
Okay, my last question, I see we've run out of time. If, let's say that the court doesn't agree with you in terms of the pleading and how to read the pleading, but thinks the more prudent course is to have a consideration of this new statute and its retroactivity by a lower court. Should we not just remit, since that was not addressed?
I think that this court is capable of deciding that issue.
Okay.
I think this court's capable of deciding.
Thank you, counsel. Counsel?
Katie Wellington, and may it please the court, on behalf of plaintiff. Defendants did not raise standing in their answer, and they did not raise standing at summary judgment despite being represented by counsel and despite having 3 separate opportunities to raise that argument, nor did they seek to vacate or re-argue the summary judgment ruling in plaintiff's favor.
So in the context of a mortgage foreclosure action, does there have to be something in the complaint asserting that you have the right to act on the note? Either that you own it or you hold it or you've been assigned it or something?
So there has to be a statement in the complaint that we are the owner, the plaintiff is the owner or the holder of the note.
And that's part of your burden to make your case out?
No, so that is not part of the elements of a foreclosure claim. So there are 3 elements of a foreclosure claim, literally hundreds of cases holding that. And that's simply that there's a mortgage, an unpaid note, and evidence of default. Standing, which is really what we're talking about here, is an affirmative defense. And standing is about whether the plaintiff has an interest in the case sufficient to bring it before the court. And that's not an element of the case. That's a separate question, and this court has long held that standing is an affirmative defense.
So let's play that one out. If you're saying, no, you don't have to prove that you're the person to actually bring it, unless they challenge it.
Unless they challenge
Okay,
it.
all right. So let's say you win, and it turns out you weren't the entity who should have brought that action. What recourse, if any, is available to someone like Mr., Ms., whatever, the Nelsons?
So I think certainly if there's a default judgment, there might be an opportunity to vacate a default judgment on account of fraud, new information, something like that.
And if there's not a default?
And I think the same rule...
But they just didn't raise it.
Well, CPLR 5015 allows for a court to undo a prior judgment due to new evidence that's introduced. So that may be one way to go back and try to get at that. Although I think that's a pretty significant bar depending on when this
Yeah, and given that the
argument is
stakes are
raised.
so high, right, someone's homestead, doesn't it seem that the legislature, of course, is more interested that you all carry that burden, rather than risking exactly what you've now described?
So I think what this new law that came into effect is saying is we're not going to make a defendant raise standing affirmatively in the answer, but that doesn't mean that there doesn't have to be some kind of determination of that at summary judgment. So where they don't raise standing at summary judgment either, I think it's not really fair to ask to us to affirmatively rebut an argument that's never been raised. But certainly the legislature thought about that and they changed the rules going forward. But under this court's long-standing precedent, procedural rules only apply retroactively to a stage in the proceeding that is not yet happened.
Let me ask you this, if the new statute says that essentially you don't waive the defense by not raising it in the answer or in a summary judgment motion, it says you can raise it at any time before there's a judgment of foreclosure and sale, how then has a waiver already occurred here? Because there is not yet any judgment of foreclosure and sale.
So I think 2 answers here is under the old rules, the proper time to raise this issue was in the answer. So that's the stage of the proceeding we're looking at, and that was long ago, 11 years ago.
But this is a pending proceeding, so why doesn't, the legislation says this act takes effect immediately. So we have a pending proceeding, it hasn't gotten to judgment of foreclosure and sale. Why wouldn't the new statute apply?
So when you're looking at the retroactivity of procedural rule, you have to look, under the old rules, has that relevant procedural step finished? And here, under the old rules, the relevant procedural step was the answer.
But what about Collazo, our case Collazo, where it was a venue choice, right, and they had sent it to the agency? We got that, the law had changed, made it plaintiff's choice, and the judge already had decided to send it, and we sent it back and said, no, under the new law, plaintiff gets to choose the forum and the venue, and it's in your court now, basically undoing the judge's decision made, let's assume, legitimately under the old law where the judge had discretion to do that. So how is that different?
So this court has said it takes exceptional conditions to apply a new procedural rule retroactively. And you looked at the text of the statute here. There's certainly nothing in the text of the statute that suggests it applies retroactively.
But
you can also look to the
seems like this isn't even a retroactivity issue, because if you take that statute to mean you can make this motion anytime up to foreclosure, that hasn't happened here yet. So if this case was going forward and all these things had happened just the way they happened here, but it was after the statute, and I understand the difference there, but you would still have this time now to make that motion. So why is it retroactive in any sense, really?
Well, I think two answers. The first is there hasn't been a lot of case law in 1302A, and I certainly think you can read Section 1302A as only addressing that initial period, which is the answer, which is to say, okay, you didn't raise it in the answer, it's preserved for summary judgment. It's not necessarily saying that if you don't even contest it at summary judgment, that's sufficient. You can raise it all the way at the end. I certainly think there's ambiguity at a minimum in the statute as to that.
So given that, I'm going to ask you the question that Judge Rivera asked your adversary, which is, would it be proper for us to say, okay, this may have been okay under the old law, but we're going to remit it to the trial court to sort out this whole issue of the effect of the new statute?
You know, certainly this litigation has been going on for 11 years. We've paid over $43,000 in property taxes and insurance on this property, and that's as of 2016. So we certainly would like to resolve this case. That said, the retroactivity issue here is quite important. There are more than 25,000 foreclosure actions filed in New York courts every year. So certainly whatever rules you set here will be very important. And I'll point out that there are a lot of interesting and important procedural questions at stake, such as even in a default action where, you know, if you take the statute to say you can raise it after a default, you still have to seek relief from the default. You still have to meet that standard, which is the excusable neglect standard.
Okay, but that's not what's going on here. But so let me ask you this, along your analysis of the retroactivity. I get your point. You've paid a lot of money. This court should just decide this. But on the issue of the retroactivity, as you seem to be analyzing it, I'm not really clear because the case is on appeal, and they have challenged whether or not they actually did preserve this question of standing. So it's not really like we are past the point of the standing, and now they're coming in and saying, oh, there's a new law that would have saved us, right? I mean, they've been challenging this. This is in part what they're doing here. So why wouldn't the statute now apply?
So under the old rule, they waited until after summary judgment to challenge.
I understand, but that's your argument against their challenge. But what I'm saying is the rules are usually cases pending. If a rule changes along the way, it applies. And so they're still challenging this question of whether or not they did properly preserve their standing challenge. Why wouldn't the new statute now apply as a consequence?
So that's
they haven't conceded. What I'm saying is they haven't conceded that point and now come in and said, oh, okay, so we lost under the old rules. That's very clear. We always agreed to that, but now we've got another shot. Instead, they've been challenging throughout whether or not they had properly preserved standing.
So when it comes to new procedural rules, it is important to look at the procedures that were in place when the parties were litigating a claim. So think about, you know, if the rules change on when you have to serve process or serve notice. I mean, you're not going to apply that new rule 11 years back in the past.
No, I know, but I'm sorry, I'm not being clear. My point is that their side has never conceded that they didn't comply with the existing framework. I understand your position, and it's been successful, but he continues to challenge it. So the consequence, it's a pending action, as Judge Stein mentioned before. So why doesn't the new rule then apply? I could absolutely appreciate your argument if indeed they had taken the position, yeah, we missed that, but here are other grounds why, nevertheless, we should be successful.
And I think it's really important here that there are different retroactivity rules for procedure. So if you were, say, litigating this issue of did you comply with a 60-day notice requirement for 11 years, and then it becomes a 90-day notice requirement, you're not going to apply that new notice requirement 11 years in the past to this procedural action. And I'll point out here, there are other procedural rules at play. Defendants have never sought to vacate that summary judgment ruling, and that's exactly what the Supreme Court held here, which is even if defendants had raised standing in their answer, the summary judgment motion disposed of it, and the court wasn't at liberty at that point in the proceeding to go back and reopen the summary judgment proceedings, particularly without some kind of motion by defendant. So we think the decision below is well-reasoned and is correctly decided, and we ask this court to affirm.
Thank you, counsel. Mr. Foley?
Yes. 1302A applies here. Just does. I mean, the opposing counsel is concerned about rights that have already vested, but nothing has been vested yet. There has been no foreclosure sale yet, so there's no reason why it shouldn't apply here. Opposing
What about
counsel...
her hypothetical that, okay, before you needed 60 days notice, and now they make a new rule, the legislature says you need to give 90 days notice.
Right.
How would that play out?
No, I think that's a very different circumstance, because that's like you lose the right to bring a summary judgment motion.
Well,
that-
isn't actually the analogy, if I'm understanding Judge Feynman's question and her point, isn't actually the analogy that you would have been challenging, no, we did provide that notice within the 60 days, and that's what the dispute is, as
Right.
opposed to conceding, no, we didn't do that within 60 days. Because I thought that's what's going on in this case. You haven't conceded that you didn't assert standing. That's your whole argument.
And that's true. I mean, like, going back to, I believe it was 2011 or 2012, we've contested standing. We contested standing on the cross motion to dismiss. I believe we...
But under the old rules, you didn't do that in a timely manner.
I mean,
Or do you think you did?
I think we did,
How?
because it's not unusual...
By denying, by general denials? Is that your...
No,
statement here?
we denied that they owned the note of mortgage, something that they pled on the face of the complaint. Because they
You
pled it and we
specifically
denied it, we
or
thereby put it at
Did you
issue.
specifically deny it, or did you deny it wholesale with most of the...
We denied it with other paragraphs as well.
Okay, and in your view, that is enough to raise standing, or was enough under the old statute? Is that your
Absolutely.
position?
They put it at issue in their complaint, right? They-
So let's just take that one step further. That means that when a plaintiff alleges certain things,
Mm-hmm.
right, and there's a general denial, not anything specific as to any specific allegations,
Mm-hmm.
then that plaintiff has to anticipate what possible defenses could be brought against each and every factual allegation made in the complaint, or otherwise they lose? Is that what you're saying?
No, I mean,
So how is this different from that then?
look, it's not, and I agree with Justice Duffy here, in the first and third paragraphs of the complaint, it's not as if they lumped together a bunch of no allegations that were unrelated. They in essence alleged standing, and then we denied it.
Right, and
Right.
so
So,
you-
but like, if I can say this about surprise, right? Because there's been a lot of focus on, oh well, we're surprised here, right?
Right, there's an
But it's really
allegation-
that second part of 3818B,
There's an
which according to the
allegation in
commentary,
the
is a sturdy foundation.
Let me just ask you this. There's an allegation in the complaint that they're the holder of the note, right?
Yeah.
And you DKI that.
Yes.
Understandably, because how do you know they have the note, right?
Right.
They then put in an affidavit saying, essentially like the affidavit we were just talking about in the prior case, along with a copy of the note attached. They move for summary judgment.
Right.
And there's no response to that.
Right.
Why doesn't that end it?
Well, I don't think it ends it because, well, we brought it up on our cross motion to dismiss. And we alerted the court and we alerted the opposing counsel that there was an issue here. And they had the opportunity to weigh in there. They had an opportunity to weigh in on that, and they actually did. It's really simple as that.
Thank you, counsel.